Strap in, folks. This case is about to test more than sobriety. Imagine being forced to wear a high-tech alcohol monitor that reports every 30 minutes, but then it spits out conflicting results. Positive at 12:42, negative at 12:47. What happens when freedom depends on a machine that can't make up its mind? Today, Judge Fleischer must decide, is this justice or just faulty tech running wild?
So, Mr. Evans, Mr. Akingpelu has bond violations that he is
drinking, and tampering. However, I have great suspicions about the integrity of these tests, because the last time he was adamant, but we didn't have any proof. This time, they alleged an allegation on the 7th. The 7th was the first day you had him coming in to test. So he was in court that entire time. He tested that day. However, they said he tampered and had alcohol in his system at 11, but at 1:30, he receives a text that's saying that he passed. So I don't know. We've had a lot of clients in here. I don't know many people who drink while in court on the day of. So I think the record would show that from your test that you had him do on the 7th. So
he didn't show up until after like 12:30 that day.
But he still tested that day.
Regarding that, I did reach out because I did notice that for the violation, he was at 49 getting tested during the time, and I obtained the scram report. I can of course send it over to you as well. I had one of my supervisors look over it again due to the discrepancy there, and it does show multiple tampers themselves, but for the tampers that detected alcohol but not confirmed as consumption, it's very much believed that it could possibly be an environmental factor while he was at 49, either due to hand sanitizer or something of the sort, because they're very low spikes that come back down very quickly. But I don't know.
Here's the kicker. Even the prosecution admits these spikes could be caused by something as innocent as hand sanitizer. Think about that. Life-altering violations triggered by everyday products. Should a man's freedom hang on a reading that could come from rubbing Purell on your hands? Drop a comment. Do you trust tech like this, or should the courts demand stronger proof?
But I don't know.
So all the violations at the time that he was at pretrial?
Yes, so not all of them, just the one that was most recently filed on him for 11/7. Is
So,
one of which was at pretrial.
what I'm saying is the exact same wording in violation on 11/7. He's at pretrial is the exact one that he got that brought us into this situation that made him have to test so much. So if we cannot trust the one that happened on 11/7,
The other violations.
how can we trust that violation?
I only saw one submitted for that one. Is there more that we haven't addressed?
I don't know. I mean, I thought there
So
were.
we had a previous one, I believe it was for his GPS. Let me check.
It was another one. So it was another one in October, said he tampered, tested for alcohol, then he disappeared. You remember I said, I don't understand how that happens. So then he gets the exact same one. And luckily he was at San Jacinto tampering, it disappears. So if that one is bad, I believe the previous one was bad. Now he did come in late 7 minutes. That was his only other violation. And we understand that it's bad. But in regards to these two tamperings, if we cannot trust the 11/7 one, I don't think we can trust the other one. And for that reason,
it says here, a
Yes.
tamper event occurred on 10/29/24 at 2:25 p.m. Alcohol was detected. They couldn't confirm because of the nature of the tamper, right?
right.
So the one thing with that one, however, is I also obtained the scram report, and I believe I sent that one over to you. I'll double check. If not, I'll send it over again. And that one showed like a high level spike with a dissipation. And the discrepancy with the one on 11/7 is that it's a very short bump that comes down very quickly. The other one showed more accuracy of alcohol that wasn't deemed to be a possible environmental factor, or the
So you're saying the 10/29 could have been environmental then?
I believe so. I don't
And he tested, and that's the day that he blew earlier that day. or he did something earlier that day in regards to testing. I'm just
We don't have evidence of that.
what I'm
Like
saying.
if you do, I mean, if
I think they checked it that day. I think it was something he had to do for the other case. But what I'm saying in regards to all these, if we were in court, the integrity of these machines are in question. I don't know if he has a malfunctioning one, but I don't see how we can rely on this scram device if it is saying that almost the exact same thing. She's saying the levels are a little higher or lower. It dissipated. However, I was told that alcohol stays in your system for a period of time and levels off. So I don't know how it can dissipate within seconds, even if it went higher or lower. And if it was higher on that day,
so if you have something, an environmental, like let's say he puts sanitizer on his hands and it drips to the leg, right? Mm-hmm. The spike would be just thousands. It would be just astronomical. So we know that there's no possible way it could be alcohol. But when they're small, then it's more the reality that it could be alcohol. But the problem is that the device is supposed to stay on the legs to confirm. And when you have a tamper as such that you can't confirm, therein lies the problem. Because we have, I mean, I understand what you're saying about the integrity of the machine, but if every single time we have someone that's tampering with it so that we can't get an accurate result, there's a problem. And I can't believe that every single one of those times, there's not a true tamper, because it can't just continue to happen and we can't get a true and accurate reading because of something that's, forbidding it from happening.
Yeah, and sometimes it can be the shoes. Like I talked very thoroughly with my supervisor today about it, just because I was confused over the matter as well. And like if you're wearing boots, it can also affect that. But the thing is, they're very thoroughly instructed, and he reports to pretrial very often, so he should be aware of all of the things that he's not allowed to do in order to tamper with it. Because even this most recent tamper where the alcohol was alleged there, that may have been an environmental factor, but it is a definite confirmed tamper. So even if it wasn't intentional, it's still showing a tamper. So I don't know if he maybe had his pants tucked in under the device, but I mean, that's why he keeps getting the PPRs.
Something is preventing the machine from doing what it's supposed to do. Mr. Evans?
If he wants to report to pretrial and have it checked out, maybe to what's today, Wednesday, tomorrow, whenever he does his drug test, I can make him an appointment for that. But that's, I mean.
But my position is this: we're here to try to make sure he's not drinking, and I understand that's very important. I agree with, and I know how the judge feels about drinking and driving. However, the day that he's in court testing, you had him do a urine test that same exact day, and they're saying alcohol on that day was a small spike. However, the alcohol on the 29th was a larger spike, and each one dissipated quickly, which means the only way you can know it dissipated is you would have to be able to test afterwards. I'm just saying, other than in a civil court or criminal court, the integrity of this machine would be in question. And now
let's do this. He's due back for a test tomorrow, right? Yes. So let's do this. Let's regroup tomorrow. Can you get me a full report of every single test that he's done?
Yes, Judge.
Every single number that you've been able to actually capture, okay? Every single tamper that you have, and I want a complete list of every single event that's happened.
Yes, Judge.
And then we'll get a copy to Mr. Evans, and then we'll talk to Mr. Akinpelu about it tomorrow.
Yes, Judge.
You know? How about that? Because I don't have any paperwork in front of me, so I know how many events there have been, and that's really the only way that we should be even going forward, is to get a full and complete picture.
And that's why I was asking for an email.
So let's do that. And then he's supposed to be here tomorrow. So if you can just advise him to come earlier than 12:30, that would really help everyone. You know?
Okay. I will do that.
And then we'll regroup tomorrow.
Notice what Judge Fleischer just did. He pressed pause. Instead of rushing to judgment, he ordered a full report of every test. That's a huge move. In court, credibility is everything, and when the evidence itself is shaky, even a judge has to admit, We need the facts straight before someone's liberty is on the
Regroup
line.
tomorrow.
Okay, thank you, Your Honor.
Let's plan maybe like 11 o'clock. Is that okay, Mr. Evans?
That's fine.
Yeah, okay, we'll do that.
All right, thank y'all.
Okay, thanks, bud.
The next day,
I think so.
Tell me,
This is in regard to.
what's the word, Thunderbird?
I got somebody's phone.
Guys, we're talking about Akin Pelu. Is he on the docket today or no?
No, you just want us to come back.
Let me give you
records.
a cause number, guys. And
I remember this case, Judge.
I'm at a loss of everything, you know? You're on 2 different felony probations, both of those for driving while intoxicated. Both of those are felonies. So it's not only do you pick up 1 DWI third, but you pick up a second DWI third. Get on probation for both of those. And now you've picked up here, driving on a suspended license. We ordered you, number 1, not to drive, and number 2, not to consume alcohol. That's all I've ordered you to do. Just don't consume alcohol and don't drive. Has anything happened upstairs?
Well, Your Honor, to be fair, I think the integrity of the machines are in question. 11/7. So when he picked up the first one on 10/29, you told him to test Monday and Thursday.
You picked up what? The machine?
No, when he when you thought it was a tamper on 10/29, he started testing Monday and Thursday, which in this case helps us. So on Thursday, 11/7, he was here in court where he tested. He tested at 12 o'clock. At 11 a.m., they got a tamper and a sign of alcohol. However, he tested clean with the test you told him to take that day. So which tells me that that machine's integrity is not correct. So if the integrity, and he's maintained that he has not been drinking either time. Every time we did the court, I promise he's not drinking. So if that machine is saying tampering alcohol and he goes and tests on 11/7 at 12 p.m., an hour after the tampering and alcohol, then he may be telling the truth. And I understand what we're dealing with, but he has tampering, sign of alcohol, and then it dissipates and there's nothing there. So
I'm on the same page as you as far as I never want to punish someone who's never done or who has not done anything wrong. That's not, we don't do that. We're the exact opposite. I mean, I scrutinize every single thing that Michael does, every case, every probable cause, I don't think I scrutinize the hell out of it. But at the same time, I also do that with people that are in front of us as well as people with charges, right?
And Your Honor, and to say off the record, I know that you do that. I know that you are a judge that will be very fair in these situations. So I'm just saying that.
So he takes a urine sample. It looks like on 11. What day was it?
11/7.
11/7.
I think the sample was taken around noon. He did 2 that day, 1 upstairs and 1 downstairs. So 11 and 1 o'clock. He had to do 2 different samples. 11, I think 07, they say he tampers and a sign of alcohol occurs. So he was here in court, but still have 2 urine analysis around the same time as that he.
Alicia,
Yes,
do you
Judge?
have a test for 11/7? Because I don't have it.
Yeah, so it's probably not in those records because right now it's just presumptive. It was presumptive, but it's negative. So nothing came back. I have it on my end here. It should be.
What time was the positive for alcohol on 11/7?
For the scram report? Let me see.
I thought it was like 11 a.m.
Sorry, normally I don't look over those reports because I don't know how to read them, but I will try to figure it out.
And Judge, I might have an unupdated report. The only BVR I have here is for a scram violation from October 30th.
Yes.
Was there another violation?
Yeah.
Okay.
So there's a violation technically pending on our end because he was coming in that day, so I addressed the violation. And so they were waiting to file it to see if judge wanted that to be filed because he was going to address it at court. And that's what we're discussing from 11-7. So that violation is pending a DVR because judge is taking action on it already.
Do we have a,
I could have sworn you said that there's another presumptive alcohol
On 11-7.
on 11-7.
No, there's a presumptive negative for the POC test that he took, our rapid test.
No, yeah, right.
On
I know that
11-7,
one.
it was a alcohol detected, but.
What time was that?
confirmed. I'm trying to read the report.
Because that's, we've got a
So I
presumptive.
got it right here from Brittany Gordon. The defendant order was obtain a scram device. The defendant's scram device has confirmed one tamper event. The tamper event occurred at 11-7 at 12:42 p.m. Now he was taking the test at 12:30
Hold
p.m.
on. Saying it was 11-7.
At 12:42 p.m. Got this email on November 11th. It went to everybody in the court. Alcohol was detected during the tamper. However, alcohol cannot be confirmed as consumption because of the nature of the tamper.
Began at 2:25 p.m. and returned to baseline at 8:04 p.m.
We also took another test with you guys on 11-7.
Yes, that was at 12:47, I believe. Let me double check.
What? So at 12:42, he tests positive for alcohol, and then at 12:47, he tests negative for alcohol. Am I right?
It was, sorry, one second. It was Tuesday, October. I'm sorry, Judge, respectfully, I have no idea how to read scram results and everything that's in my email, but I can check on the drug test for you.
Well, so the 11-7, we have the email on November 11th, okay? Then if you go to the email she just sent me, it tells you when the lab test was submitted. Hold on. She just sent me this email. And this email from Average Size Individual Screening Report on 11-7, it says that it was one of the collection times was at 12:08 p.m. on 11-7, 12:24. He did negative. So that means while he was in court, he would have to drink. But then he took another test after that. I don't know what the other test is at. What I'm saying, Judge, I'm just saying this whole, if we were in trial right now, the whole integrity of these machines would be in question right now because in the previous test, because the same exact message that we got on 11-7 was the same exact message that we got on 10-29. Scram temper, alcohol cannot be confirmed, same thing. So what I'm saying at this point, he has maintained to me, and I know he's messed up numerous times. He's maintained to me that he has not touched alcohol since his last situation. He did drive. He's wrong for that. But these new testing procedures that he's got,
What do you mean he did drive?
that's why we're in here, because he was driving.
So due to the charge, though.
Yeah, he did drive.
I hope to God that you're not driving this driving.
No. I'm talking about due to discharge. While we're back in your court.
Okay.
Judge, I don't have any of those emails. I think the best thing at this point is we can set this off for a bond hearing and I can bring Ronald Grant here to clarify all of this with all of us because none of us are experts. We don't know how to read the report. I know what defense is saying, but I can't even tell you the veracity of anything that's happening because I don't even have these emails.
Yeah. So
I can subpoena Ronald Grant. We can do this next week. I can get it done.
Let's not disrupt other people's lives. It's
Sure.
not necessary.
Sure.
He is saying that we have a test, and I mean, what Mr. Evans is, test 11/7, the scram at 12:42, there's a positive, but then 7 minutes later, there's a negative when he goes up there to test. The machine's obviously messed up if that's true.
So
Is that
here's
what-
where we land. Multiple tamper alerts, conflicting alcohol results, and a judge openly questioning the integrity of the scram device. This case shows just how fragile justice can be when technology becomes the evidence. Faulty readings could mean jail for some and freedom for others.
Stuff
What
if
do you
that's
think?
true.
Is that what you're saying, Felicia?
And then I've also noticed on the screen report, I asked them, because again, myself, I cannot acquire this, I have to have it provided from our case managers and the, provider of the device. But the screen report, the only one that I'm seeing attached to the email is for the DVR that was filed, for the 29th, but I'm not seeing the one from 11/7.
So we don't have a scram report from 11/7.
We have an
It's
email.
not attached in the email, but we do have the rapid test when he was on site.
The rapid's negative.
Yes, and then we were informed, like I informed you yesterday, of the pending BVR violation for the 11/7
Hold,
at that time.
hold on. So, Judge, we don't even have the scram report. We don't know what the presumed blood alcohol content was. It's very possible that if he had a very low blood alcohol content or breath alcohol content, that the scram detected that he could have come to court, taken a test and gotten a presumptive negative because it's already been eliminated from his system. That's why I'm saying I believe we need to get that scram report from 11/7, get what the tamper is, have Ronald come up here and tell you what's possible or what's not possible, because he's the expert, and I get what defense is saying, but he doesn't know either.
But
I don't think-
let me respond to that. What we do have is a test that happened at 12:07.
Right.
And I can show you that one. So even if we don't have the one that she spoke of, 12:47 that she referred to, we have a test right here, which will make us have to believe that he, while in court, he drank some alcohol if these machines are deemed to be valid. And we were about to reprimand him for the 11/7 situation, but now it's time to.
Reprimanding or remanding, he's suggesting that we just do it at a later time to get everything all together.
Okay, well, in the meantime, since these machines,
I'm not gonna take him into custody until I know 100%.
but can we, because he's working, he's come here. The reason why you put him on Monday, Thursday is because these tamper going down. So we're gonna wait to see if these machines are valid. I'm requesting that we go back to the same bond conditions that we had prior to the tampering. So he does not have to miss work twice a week, coming out here and testing, because all we know, this could be a big mistake.
And I would strongly object to that, Judge, based off what he's on probation for right now.
But the only reason why we're doing the twice testing is because of the tampering. So if the tamperings are invalid, why are we doing something extra when that wasn't what the judge originally wanted?
Well, because there's an allegation right now. We need time to confirm or deny that. But for now, the safety of the community warrants these bond conditions, in my opinion, Judge.
And I strongly disagree.
Mr. Evans, we have a curfew on, right?
I don't think we have a curfew. We just have the scram. You just
He
have
has
the
a
scram.
curfew, Judge.
Well, so, okay.
So,
Are you working now?
yes, sir. Working with a hospital in, I have a project with Epic. So I assist physician and nurses on the software they use. Called Epic. The software is called Epic.
I don't want anyone to lose a job. I mean, the last thing I want is someone to lose a job, right? But I have to know that you're not drinking. I know that you tell me no, but all I have are consistent problems. Every time we had you on docket for whatever it may be, there was always problems. Every single time you came in here with the DWI, there were issues. Every time you came in here with the suspended license. And I'm telling you the history that we have,
I understand.
you know?
I understand.
So that's why it's hard to believe all these coincidences when the nature of my relationship with him was every time we had a case, there was at least 3 BVRs. Every single.
And I was I was completely on your side. I thought he was telling me not the truth. But once I saw that he was in court that day.
Let's do this. Let's set it for next week. Let's get every record, subpoena the person, right?
Can we do next Friday, Judge? Is that possible? I'll be in trial next week till about Wednesday. Can we do next Friday? Okay,
or not Friday, Thursday? Or, okay,
Friday's okay. Yes, Judge.
yeah, and do you want me to waive the appearance?
Can we, I just want you to waive the test.
Oh, okay, I will.
Yeah.
I will.
Yeah, that's all I want.
He's gotta be here for the next PBR here.
No, you can't, yeah, that's fine. Yeah, I just want him to be able to work. So thank you so much.
I'm tired of having to deal with one problem or the other. I would suggest that you go get a new machine so that we know that there are no more issues. Go down there, tell them, hey man, give me a new machine so that we know if there are any issues, that way you can make sure that you get a new one. Felicia, can we send him for a new one now?
Yes.
Just to make sure that, Okay, so you guys pick it, we'll do it. And then we'll do it. We'll take them off that.
Thank y'all.
What do you think? Was the judge right to hit pause and dig deeper? If you found this breakdown as shocking as we did, smash that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom drama right here on Inside America's Courtrooms.